are all superseded by the tables in my rebuttal testimony, simply because of updates in data calculations.
Subject to the one correction in the updated tables in the rebuttal testimony, we ask that his direct testimony be admitted into the record as if read verbatim.
Okay, Mr. Collins, pre-filed direct testimony will be entered into the record as though given orally from the stand.
And Mr. Collins, did you also, in preparing your direct testimony, create and prepare exhibits 1 through 35 attached to your direct testimony?
Yes.
We move that those 35 exhibits attached to his direct testimony be moved in as a next hearing exhibit.
Mr. Collins, exhibits will be moved into the record as exhibit number 50.
Thank you very much. And Mr. Collins, did you, in preparing for your testimony today, also prepare rebuttal testimony in the consolidated dockets?
I did.
Do you have any corrections to your rebuttal testimony?
I do not.
If I asked you the questions in your rebuttal testimony today, would you have the same answers that are in your rebuttal testimony?
Yes.
Mr. Chairman, we move to admit his rebuttal testimony into the evidence as if repeated here for today verbatim.
Mr. Collins' rebuttal testimony will be entered into the record as if given orally from the stand.
Mr. Collins, did you also prepare rebuttal testimony that you've already referred to?
I did.
And that contains some of the updated tables?
It does.
And do you have any corrections to your rebuttal testimony in this case?
No.
If I asked you the questions in your rebuttal testimony today, would you have the same answers that are given in the rebuttal testimony?
Yes.
Mr. Chairman, we move that the rebuttal testimony be entered into the record as if repeated here verbatim.
Mr. Collins' rebuttal testimony will be entered into the record as if given orally from the stand.
Thank you, Mr. Chairman. And Mr. Colin, did you also prepare 8 exhibits to attach to your rebuttal testimony?
I believe there are 9.
Thank you. Did you prepare 9 exhibits?
Yes.
Thank you very much. And Mr. Chairman, we move that all 9 of those exhibits to the rebuttal testimony be entered in as hearing exhibit 51.
Mr. Collins' 9 exhibits will be entered into the record as exhibit number 51. Also, we need to ask about in his direct exhibits attached to his direct testimony, I think you said 35, and I think we have 36. We wanted to clear that up.
There are 36. That's
36.
Yes.
Okay, so we'll have 36 in that. That's
Thank
an
you
exhibit
very much,
50.
Mr. Chairman, Hearing Officer Butler. Mr. Collin, after late in the process, did you have an occasion to prepare supplemental rebuttal testimony based on an additional alternative plan by the joint applicants in this case?
Yes.
And do you have any corrections to your supplemental rebuttal testimony at this time?
No.
And would those be the answers if I asked you those questions today under oath?
Yes.
Mr. Chairman, we move that those supplemental rebuttal testimony be entered into the record as if repeated here orally today.
Mr. Collins' supplemental rebuttal testimony will be entered into the record as if though given orally from the stand.
Mr. Collins, did you, in preparing all this testimony, and particularly preparing for today, did you prepare a summary of all of your testimony with some of the attachments and charts to share with the Commission?
I did, yes.
Please let Mr. Thompson pass that out. Commissioners, it is in your notebooks that were provided on the first day. Mr. Collins, would you please give that summary now for the Commission, please?
Yes. Good afternoon, Mr. Chairman and members of the Commission. I provide direct surrebuttal and supplemental surrebuttal testimony and exhibits on behalf of the ORS addressing 4 categories of issues. The first category that I address is the presentation and quantification of the ORS optimal plan for recovery of the new nuclear development costs, less related regulatory liabilities. The second category that I address is the comparison of the customer impacts measured in terms of revenue requirements under the ORS optimal plan, which is based on a traditional utility cost of capital, including a return on equity, to the ORS optimal plan under 2 different securitization financing scenarios or alternatives, and to the applicant's proposed merger customer benefits plan, which I will refer to as the CBP, and the South Carolina Electric and Gas no merger plan, which I'll refer to as the no merger BP for benefits plan. I also provide a comparison of Dominion's new alternative CBP and compare this plan to the merger CBP and the ORS optimal plan. The third category is the deferral and recovery of the Baseload Review Act transmission costs in terms of the revenue requirement. And the fourth category is merger issues, including potential synergy savings and necessary commitments and conditions to ensure that customers are not harmed now or in the future if the merger proceeds. Now, I have a table that summarizes the first category of issues, which is all of the effect on the customers in terms of revenue requirements. It's a little hard to see, but I'll just walk through this.
Mr. Cullen, it's in your summary.
It is. In fact, it's in the Commissioner's notebook, as I understand it. But the first part of the ORS optimal plan is the termination of the revised rates on the effective date of the order in this proceeding. That's a rate reduction of $445 million because that's what the revised rates recover annually right now. Then the second thing is the termination of the experimental rates, which is a credit, a negative rates, and that's at $367 million annually right now. And then there would be an increase to recover the N&D costs less the related regulatory liabilities of $85.9 million, and then a reduction for the income tax savings due to the Tax Cuts and Jobs Act of $98.7 million, and then a one-time reduction pursuant to your order in the tax proceeding with respect to the savings this year in 2018 that are not being flowed through to customers right now, but you directed the utilities under your jurisdiction to defer. So that's a one-time refund, and that's why it shows up only in the 2019 year, and then 2020, it's done. And then that would result, if there is no merger, a rate reduction of $158.5 million from present rates today in 2019, and there would be an increase because of the drop-off of the one-time refund or that tax savings regulatory liability in 2020. So the net reduction in 2020 would be $90 million. That's not incremental. That would be from today's rates. And then finally on this table, if the merger proceeds, then there will be synergy merger savings based upon Dominion's historic experience with other merger activities. And we estimate that at $35 million in the first year, growing to $70 million in the second year in 2020. And we propose a merger savings rider to flow through those savings to customers in those years.
Mr. Cullen, can I interrupt if you don't mind? Because it's helpful to me to understand, when I'm not an expert like you, that the first 2 lines, all they do is zero out the revised rates so that we start at the no N&D rates, right?
That's right.
Right.
The first 2 lines take away the revised rates that are presently in effect. And the second line takes away the experimental rate credit that is presently in effect. So right now, the recovery through the combination of the revised rates and the experimental rates is the net of the $445 million and the $367 million, or $78 million. That's what customers are paying right now for N&D costs and BLRA transmission costs.
And so, Mr. Cullen, that's the annual total recovery right now under the experimental rates from customers.
Yes, that's correct.
But and then the third line is actually the ORS plan of what the ORS plan suggests the ratepayers should have to pay from the NND cost out of this project, right?
That's right. That is recovery over a 20-year period of the N&D costs less the related regulatory liabilities. Regulatory liabilities reduce the N&D costs, and it uses a common equity rate of return of 9.1% and a debt cost of 5.56%, and it has a levelized recovery over 20 years. Normally, in a utilities revenue requirement, it starts high and it goes down, and as the costs are depreciated. In this case, what we did is we developed a recovery plan that was like a mortgage. And so it has a constant amount of recovery from customers over each of the 20 years in the recovery period. And then at the end of the 20 years, the $85.9 million would go away and be done.
And Mr. Cullen, just to keep it simple, the first two zero out. The third line is what ORS recommends they recover. And you just a minute ago said what the current recovery on an annualized basis is under the experimental rate is actually less than this number, isn't it?
Yes. Yes.
Okay. And then the next two lines are tax savings that are unrelated to.
I hate to interrupt, but this is turning into a direct examination. I think the witness has a summary. The witness has prepared the summary. The witness needs to give the summary.
That's what we've asked for. So.
Okay, that's fine. I appreciate that very much.
Now, I have another chart that is also in the summary, and it shows up on page 4 of the summary. And this provides a comparison of the annual requirements under the ORS optimal plan, which is based on the traditional utility cost of capital, including a return on equity. And we compare that, or I compare it on this chart, to the securitization and to the applicant's proposed customer benefit plan and the no merger benefit plan. And you can see that the orange line is the recovery under the ORS optimal plan. And the green line at the top is the recovery under the no merger benefits plan. That's where there's no merger. South Carolina Electric and Gas remains an independent entity owned by SCANA. And then the yellow line is the merger customer benefits plan. So if that merger goes forward, then that would be the revenue requirement. And you'll see that there's the $1.3 billion in 2018. We showed that as in 2018, but it would actually occur at the beginning of 2019. We just wanted to differentiate that on the graph so that you could see that there was the $1.3 billion rate credit up front under the proposed customer benefit plan, and then there would be recovery at about $310 million each year thereafter for the first 8 years, and then it would decline. And then I have another table that further describes the different components of the cost recovery under the different plans. And you can see that the net present value of the ORS optimal plan, which is that first numeric column, is $782.8 million. The far right column, the net present value of the recoveries from customers under the Dominion customer benefits plan, is $1.061 billion. So there's a difference there of roughly $260 million of additional recovery under the Dominion merger plan, and that's even with the $1.3 billion upfront rate credit. And then what I did was I thought it would be helpful to the Commission if we compared what the recoveries from customers would be on a 20-year levelized basis, at least for the three plans, ORS optimal plan, the first column, securitization in the second column, and the final column is the Dominion merger. And you can see that the ORS plan provides the company recovery of $85.9 million, and the equivalent to that would be $124.7 million, but under the customer benefits plan. But keep in mind that the customer benefits plan has a $1.3 billion upfront rate credit, so that really, in exchange for getting the $152 million rate credit up front effectively, customers will pay $277.5 million on a 20-year levelized basis. So, it's a pretty significant difference. But again, the major part of that, or a major part of that difference, is the $1.3 billion upfront rate credit, how you factor that in. And the next chart shows how these costs are recovered from customers, or what costs are covered or recovered annually. And you can see that the first line are the NND costs. So you can see, for example, and these are all on a South Carolina retail basis. You can see that under the ORS recommendation, the optimal plan, it's about $2.683 billion. And you can see under the Dominion merger plan, it's $3.138 billion. And of course, that's before the $1.3 billion rate credit. But then you can see the regulatory liabilities for the Toshiba proceeds. I'm sure you're familiar with that at this point, but Toshiba, under a settlement agreement because of a parental guarantee, provided cash to South Carolina Electric and Gas. Was partially reduced by a Citibank monetization, but that effectively is a refund or a credit against the N&D costs. Toshiba basically had to refund part of the money. And then there are various other regulatory liabilities. For example, there's a refund of revised rates. There's a return on these regulatory liabilities. And then there's all of the tax issues. I won't bore you with those right now. In addition to my rebuttal testimony on these issues, I respond to quite a few Dominion and South Carolina Electric and Gas rebuttal witnesses on specific issues with respect to the ORS optimal plan. And I won't go through all of the detail of that. You have that in front of you with respect to the testimony and the summary. But I do want to highlight a couple of things because they are fairly significant. And one is that we have this issue of the NOL ADIT. NOL means net operating loss. ADIT is an accumulated deferred income tax issue. And the NOL ADIT is a measure of the tax benefits that can't or haven't been able to be used yet. Like the abandonment loss created a tax deduction, a reduction in income tax expense, and what we refer to as a liability ADIT. But because the company couldn't use all of that and get a refund for taxes that they had already paid, they get to carry that forward. Well, that then creates an asset, in addition to rate base. The liability ADIT is a subtraction from rate base. So you have to take into account all of these additions and subtractions. The company came in and said, listen, we will allocate the liability ADIT between the allowed and disallowed costs. So customers, you get the ADIT on the allowed cost, but we keep the savings on the disallowed cost. We totally agree with that. That's fair. But then what the applicant said, but we get to keep the entire, or get recovery from customers of the entirety of the NOL ADIT, which we argue is completely unfair, unbalanced, and inequitable. I mean, you can't get part of the tax benefits for the disallowed costs, which we agree with, but then get the customers to pay for all of the tax costs. There should be some symmetry there. And we propose a methodology for calculating the amount that follows the allowed N&D costs. So the ORS optimal plan provides recovery of all of the allowed N&D costs minus the regulatory liabilities, and all of the tax effects follow the allowed costs. That's not the case with the applicant's proposal. And then I also recommend that the Commission direct South Carolina Electric and Gas to defer the BLRA transmission revenue requirement. The applicant's proposal is to continue to recover the return on a portion of the BLRA transmission costs through revised rates, and then to defer the incremental revenue requirement going forward. The ORS optimal plan says we agree with part of what the joint applicants propose, but we recommend that you take out all recovery of those transmission costs, not disallow them, but take out the recovery in revised rates, defer a return on all of those BLRA transmission costs, and then review those costs in the next rate case. And then finally, I address merger conditions with respect to commitments that the applicants have made, but they have made them in the form of testimony or in their application. There's not really a single document that includes everything that we think should be included. So I've accumulated these commitments from the different testimonies and exhibits and things like that, and I've added other conditions that the ORS believes are necessary to find the merger in the public interest and that it would not harm customers. And I've made a comprehensive list of those. And I support some of those additional conditions, and other witnesses for the ORS support some of those conditions. So that concludes the summary of my testimony.
Chairman, we ask y'all to accept the summary and his testimony as direct, and he's available to cross-examination.
Thank you. Okay, we'll go to cross. Mr. Gile?
No questions, Mr. Chairman. Thank you, Mr. Cullen.
Thank you. Other parties?
Good afternoon, Mr. Collin. I am Emily Medlin. I represent the United States Department of Defense and all other federal executive agencies. I want to talk to you just briefly about securitization. If there was enabling legislation for securitization of allowed new nuclear development costs, would that result in a reduction in the cost to ratepayers in ORS's proposed rate plan and the Dominion SCANA's plans?
Well, it would in the ORS plan. I don't know that Dominion actually would modify its plan for securitization. I think that they've indicated that they would walk away from the merger. But with respect to the ORS plan, it would reduce the cost to customers by a significant amount, as much as $50 million. So instead of that, if we go back on the original table here, the third line, the ORS plan recommends an increase of $85.9 million to recover the new nuclear development costs less the related regulatory liabilities. Under securitization, you can see on the next chart that it would be $35 million annual recovery. And the reason for that is there are some tax changes as well, because you would sell the right to collect the N&D costs. But the primary reason is that you're financing 100% with debt, and low-cost debt, because it would be high quality, issued by a special purpose entity. And most likely, it would be a unaffiliated third-party special purpose entity. In the financings that we have seen, securitization financings of storm costs, stranded costs, other large dollar amounts of costs, where there's enabling legislation that basically puts effectively a guarantee, a governmental guarantee of recovery, then investors are willing to step up, advance the funds, and in the form of what is called securitization financing. Those funds come into the utility, the assets go off the utility's books because they now will belong, or the right to collect will belong to the unaffiliated third-party special purpose entity, and then the utility will have the cash to basically pay off all of the financing that it incurred for those new nuclear development costs. It's really an incredible form of financing, and it really is a much lower cost of financing, but there needs to be some type of governmental guarantee, really, in order for the market to underwrite debt of that magnitude.
Thank you. And I believe you answered my second question as to why there would be a reduction in the cost through securitization. But if you have anything else you'd like to add.
No, I'm sorry, I went a little long on
Okay.
that one. So.
All right. Well, thank you. That's all I have.
Okay, you're welcome.
Thank you. Other parties?
Honor, hopefully again, Mr. Chairman, I'm going to use the Elmo if that's all right. Good afternoon, Mr. Collin. How are you?
Good.
My
Remind
name-
me who you are. I'm sorry.
No, there's no reason you should know who I am. My name is Will Cleveland. I'm an attorney with the Southern Environmental Law Center, representing the Coastal Conservation League and the Southern Alliance for Clean Energy. So thank you. If I'd like to start by just following up on that securitization question.
Sure.
Is it your understanding that one of the most important pieces of this case is for the Commission to determine the total amount that is legally recoverable under the BLRA?
Yes.
And then would you agree that whatever the Commission decides that amount is, with securitization, you can further lower the amount that ratepayers have to pay for this project?
Right. There's no question. If securitization financing is available, it would be essentially 100% debt financing at of high quality debt at a very low cost, and that would be far less expensive than a traditional utility cost of capital.
It's purely a mechanism designed to save ratepayer dollars.
It is, yes. But it has the additional benefit of providing South Carolina Electric and Gas a significant amount of cash to pay down its capitalization by whatever the securitization financing is. So it gets the assets off from its books, it gets the debt and the equity off from its books. So, I mean, it definitely is a win-win situation unless you're looking for the equity earnings.
Well, and if you have that cash, you could actually reinvest it into return-earning capital, correct?
Yes, that's correct. Yes.
This, sir, is the table from your summary. Is that correct?
Yes.
It presents the no merger option, the Dominion customer benefits plan, and then the two ORS options. Is that correct?
Yes, that's correct.
Do you know what the current experimental rate is?
It's I do in terms of revenues. It's a $367 million revenue credit against the $445 million of revised rates.
You know where it would fall on this chart? It's about $125 a month. Is that correct?
I don't know on the per customer basis.
That's all right. Is it fair to say that, or do you know whether the experimental rate is somewhere below the Dominion offer in terms of cost?
Well, I think maybe you're talking about the combination of the revised rates less the experimental rates?
Yes,
Okay.
that's correct.
It's about $80 million of current recovery net of those two rates, and that would be roughly comparable to the ORS recommendation, which is the blue line there.
So, but I guess my question is the rates that are currently in effect right now is somewhere around here. Is that correct?
No, it's closer to the 80, a little bit under 100 million. I think the company is collecting right now about 78 million.
So it's down here
Yes, yeah,
right now.
yes,
And SCE&G, to your knowledge, has not gone bankrupt at that, correct?
it has not.
Okay. So, I don't know if you were here the other day when Mr. James was testifying, but my colleague asked him some questions and he deferred to you. Were you here for that?
No, I wasn't here.
Do you know whether the joint applicants have said that they will not offer the customer benefits plan unless the commission approves the merger?
Well, yes, I'm aware of that, and I think that would be logical. I mean, the customer benefits plan has certain aspects of it that are tied or linked to the Dominion acquisition.
Are you also aware that Dominion has said that if the commission approves the ORS optimal plan, that it will not close the merger? Is that correct?
I am aware of that.
Okay.
And I would say this, that the ORS is certainly aware of that and developed the ORS optimal plan independently of the merger. So in other words, the only thing that's different between the ORS optimal plan with with or without the merger is the merger savings rider and the conditions related to a potential merger. But other than that, the ORS optimal plan is the rate-making treatment for the N&D costs less the related regulatory liabilities.
And just for clarity, the ORS optimal plan without the merger savings is the blue line?
Yes.
And is it accurate that ORS's position is that SCE&G could implement that rate and survive even without the Dominion merger?
Yes.
Turning to those merger savings, is it correct that Dominion has refused to quantify or even guarantee to customers that there will be merger savings?
That is correct. Dominion has indicated that they expect efficiencies, which I think is their way of saying economies of scale or savings. But to date, Dominion has not quantified or estimated those savings.
In your experience, have you been aware of and followed other utility mergers that have happened elsewhere in the country?
Yes, I personally have been involved in probably 24 or more utility mergers and acquisitions.
And in your experience, are merger savings a typical component of those mergers?
Yes, they are. That's one of the factors that the acquiring company considers. And in years past, the acquiring company would come in and offer to share the savings with customers to basically get the deal done and provide customers a portion of the savings, but then they would retain a portion of the savings as well, more or less as an incentive to do the deal. But over the last 10 years, that has fallen by the wayside, and it has been the practice of acquiring utility holding companies to not provide estimates of merger savings, but then once the merger is consummated, to begin immediately to achieve those savings.
Do you think that the decision not to calculate and provide those merger savings gives the Commission a full picture of what this merger would do for its SC&G customers?
It does not, and that's why I looked back to Dominion's historic experience as far as acquiring other utility companies, and the two that I think were most relevant in my analysis of this were Dominion's acquisition of East Ohio Gas and Hope Natural Gas, where they achieved savings between 30 and 40% in non-gas O&M expenses within 2 years of the merger.
Mr. Cullen, I believe you testified during your summary that you believed that merger conditions should be incorporated into one document and made binding on the company rather than left in the testimony. Is that correct?
Yes, I think that makes sense. That way everybody can see the list of commitments and conditions in a single document, and the Commission can say, we either do not oppose or approve it or find it in the public interest, or whatever the characterization would be, subject to these commitments and conditions. And you have something that is everybody can look at. It removes the issues of ambiguity in the next rate case, for example. In other words, some of the conditions would be you don't recover the cost of the transaction of doing the deal, or you don't recover the cost of achieving savings, both of which are commitments that Dominion has made in their testimony and in their application. But I really think it needs to be an exhibit in your order so that it's actually in there. And we approve if you, whatever you do with respect to the merger, if you find it in the public interest or if you approve it or whatever the legal standard is, I also recommend that you approve these conditions and commitments. But they're
I'd like
there.
to talk about one of those recommendations, please. This is page 75 of your pre-filed testimony. Is that correct?
Yes.
And specifically, I'd like you to read, if you wouldn't mind, lines 26 to 29, please.
Yes, there are valid concerns that after the merger, SCE&G may preferentially purchase products and services from Dominion affiliates when other unaffiliated third-party competitive suppliers may offer comparable products or service with the same or greater reliability and at a lower cost.
Would you mind reading the next sentence, please?
These products and services could include natural gas supply, transportation, and storage, all of which are competitively available from unaffiliated third-party suppliers.
Do you still agree with that recommendation?
I do, yes.
Thank you. I'd like to ask you some questions about one of those things which you identified, which was natural gas transportation, if you don't mind. This is actually page 4 of Mr. Seaman Wynn's testimony. And lines for you. And he's talking about the various contracts for natural gas firm transportation that SCE&G currently has, and he identifies several different pipelines and volumes. Is that correct?
He does.
Are you familiar with this testimony at all?
I've read the testimony. I'm not familiar specifically with the facts, but I've read the testimony, yes.
But the contracts that he's talking about are for 212,194 million British thermal units on Southern, 110,458 million BTUs for Transco, and 456,427 on DECGT. Do you see that?
I do.
And do you see on lines 10 and 11 where he says currently the long-term contracts have expiration dates at various times through 2084? Do you see that?
I do.
Do you have any reason to disagree with those?
I don't know. I have no reason to disagree, but I don't know personally.
And do you know who currently owns DECGT?
I do not.
Okay. Do you know how much SCE&G customers pay for this capacity from here now until 2084?
I do not. I'm sure it would be in billions of dollars, however.
Billions of dollars?
Yes.
Yeah. And do you know how SCE&G recovers those costs?
To the extent that the natural gas is used for electricity generation, it would recover it through a fuel adjustment clause, and to the extent that it's used to supply the natural gas distribution part of the business, it would be recovered through a purchase gas adjustment.
Have you read the testimony that my clients filed from Gregory M. Lander in this case?
I believe so. I don't have an immediate recollection of it, but I believe I read out all of the testimony.
Now, just to be clear, Your Honors, I'm not about to ask Mr. Cullen if he agrees with the facts or conclusions, but I would like to ask him a few questions just to get his understanding of that testimony and then ask him some questions about how it might apply in South Carolina, if that's all right. Mr. Cullen, this is page 8 of Mr. Lander's pre-filed testimony. Do you recall seeing this?
I do.
Okay. And would you accept that in his testimony he's describing the contract that Dominion's regulated utility arm in Virginia has signed via its subsidiary VPSE with a separate Dominion entity, Atlantic Coast Pipeline LLC?
That's my recollection. Again, I don't have personal knowledge of any of this, but that's my recollection from reading it.
Is that the kind of affiliate contract you were talking about in your testimony?
It is.
Did you read Mr. Lander's rebuttal testimony in this case?
I don't recall.
Okay. Going back to Mr. Lander's direct testimony then. This is page 10 of his testimony, lines 16 and 17, where he talks about his calculation that the precedent agreement we just discussed in Virginia will increase customer costs in Virginia by between $2.5 and $3 billion. Do you see that?
I see that.
Again, I assume you haven't reviewed that, and I'm not asking you to verify his conclusions, but do you see that he has reached that conclusion?
I do see that, yes.
Have you heard of the Atlantic Coast Pipeline outside of Mr. Lander's testimony?
Yes.
Okay. Are you aware that last Friday, Dominion announced that the costs of that pipeline have now increased to $7 billion?
I was not aware of that.
Business Journal article that was published just earlier or last week. And this is Lynn Good from the company stating that the project partners have re-examined the construction schedule and cost estimates. And based on these changes, we now estimate costs in the range of $6.5 billion to $7 billion. Do you see that?
I do.
Do you have any reason to disagree with that?
I just don't know. I don't agree or disagree. It is what it says.
So at least according to this news article, we have a project that is billions of dollars over budget and years behind schedule. And at least according to Mr. Lander's testimony, will be a net loss for those ratepayers. Is that correct?
That's not quite my understanding of Mr. Lander's testimony. My understanding of his testimony is that the cost of the affiliate natural gas purchases will be in excess of market prices. I think that's my understanding. But his testimony really speaks for itself.
Well, and I'm going to circle back to asking questions about South Carolina now, since I know you have not spent much time in Virginia working on this case, at least. And my ultimate question is this. Are you concerned about affiliate contracts like the one we just described in Virginia happening here in South Carolina?
Yes, and that's why the ORS included that condition on the list of commitments and conditions that we think are necessary if you either approve the merger or find it in the public interest, because we're very concerned about affiliate abuse.
Do you think it would be good practice for the Commission to impose, as a function of this merger, that Dominion be required to get approval from this Commission before it signs those contracts with itself?
I don't really know what the process is here in South Carolina. That may be a requirement already. I don't know.
To the
But if
extent
it's
it's not
not-
already a requirement, do you
It's
think
not a requirement. I think that something of that magnitude, you're talking about billions of dollars, would be appropriate to have the Commission review that
before it's signed?
before it's signed. And again, I don't know procedurally whether there's an existing process for that or that would be something, a new undertaking. Simply don't.
Thank you. No further questions, Your Honor.
Thank you. Other cross. Mr. Ziegler. Whoop, hang on. Mr. Kaufman.
Afternoon, Mr. Collins.
Hey, good afternoon.
Is that better? Yes. My name is John Kaufman. I represent AARP in this case.
Very good.
Good to see you this afternoon.
Good to see you.
And
Met you before, I believe.
I am feel very fortunate to be speaking today with a chartered global management accountant. And I think,
Laugh at it, right?
but you're a certified public accountant, and you obviously have 40 years of experience.
Yes.
These type of matters, and I have some rather global questions to ask you.
Very good.
And you seem like the right person to kind of put this whole case in perspective. When you say that ORS is recommending that current rates be reduced by about $158 million without the merger, or about $193 million with the merger. That is assuming that is from the rates that are currently being paid with the experimental discount in there.
Yes, that's correct.
Right. And so if the ORS optimal plan is approved, consumers should see a noticeable reduction in their rates.
I would think so, yes.
Right,
I mean, that follows.
Right. And I think that's clear to everyone here, but there's a lot of people listening who may be members of the public and just wanted to kind of see how this actually impacts their monthly utility bill. Now, have you had a chance to read AARP's expert witness Scott Rubin's testimony in this matter?
I recall that I did.
Yes. And did you have any did you do any calculation of what the economic impact of it would be to compare it alongside the other scenarios you've reviewed?
I did not.
And do you understand that the bottom line from his recommendation is simply that the BLRA payments cease after December 31st, and that there'd be no refund of the $2.2 billion that ratepayers have already paid, but that there would be no further recovery?
I don't recall the specifics. I'm sorry.
But you do recall that he's recommending a different cutoff date than ORS.
Yes, I do recall that.
One that is either in mid-2013 or mid-2014 as opposed to March of 2015.
I recall that, yes.
Right. Would you agree with me that this case is more or less, the main issue that we're wrestling with here today is about what to do with the $4 billion that is still related to this project, and roughly assigning that cost to shareholders and ratepayers?
Yes, that's one of what I would consider three major issues in this case. The other one, of course, being the merger, and then the third one would be the savings from the Tax Cuts and Jobs Act.
So before it was ultimately abandoned, we're looking at about $5 billion that was spent on the NND project. Is that
4.7 billion, right?
And after what's already been written off, we're left with trying to allocate $4 billion. Is that roughly?
4.3 billion, right?
And 2.2 billion of that has already been paid by the customers. Is that right?
No. The customers have already paid 2.2 billion, but not of the principal. They've paid a return on the NND construction work in progress during the construction period.
So
it's like running interest, basically.
So would you characterize SC&G's position in this case is that the roughly $4 billion be put on the bill for the ratepayers?
Under the no merger scenario, that would be right before any offset for the Toshiba proceeds, for example. But under the customer benefits plan under the merger, there are some additional write-offs that Dominion has offered to take up front.
Okay. So just in talking in total dollars and at a global level here, how much would the ORS optimal plan require ratepayers to recover, responsible for?
Yeah. If we can go back, let's see, I don't think I have my chart anymore or access to it, but in the summary and in my rebuttal testimony, you can see that on page 5 of my summary, we have the tables, and you can see that the prudent and allowed NND costs on the second table on page 5. You can see that under the ORS plan, the NND costs are $2.683 billion, and under the Dominion mergers, they're $3.138 billion, and then the next to the last column is the no merger, $4.0 billion.
Okay. Great. And you wouldn't have any ability to roughly estimate what Mr. Rubin's recommendation would equate to, would you?
I don't know. Okay. Not sufficiently familiar with it.
But it would be less than that, less than the ORS.
It would because of the earlier cutoff date.
And, excluding the merger savings and the tax effects.
That's correct, yes.
And there's another recommendation in this case as well from the Friends of the Earth whereby ratepayers would be totally exonerated and would have to pay nothing for the NND costs.
That's my understanding.
I'm going to ask a question, I guess, that I think some folks have danced around, but I know that at least Commissioner Williams has had a question about, and that is the possibility of a bankruptcy filing, that the utility would would choose, if they didn't like what the commission approved in this case, that they would have that option. Do you have a reaction as to whether about the likelihood of that if the commission approves the ORS optimal plan?
Well, I'm not a bankruptcy lawyer or even a lawyer, but I do have an understanding of there have to be certain thresholds before an entity can file for bankruptcy, and I don't think anybody from Dominion or any witness from South Carolina Electric and Gas has stated in testimony that even under the ORS plan, which they both dislike strongly, that would trigger a bankruptcy. All of the discussion, all of the testimony has been that, well, that would put the company's credit metrics under more pressure than they are already. But none of them has come forth and said, oh, well, this is just going to push us over the edge into bankruptcy. So I think that should tell the commission that that's really not an issue before you.
And if the utility were to make that decision, any potential harm from that bankruptcy would more or less be self-inflicted, wouldn't it? It would be ultimately the result of the mismanagement of this project?
Well, I don't think that the utility can just make the decision in a vacuum. In other words, there has to be certain thresholds, one of two, as I learned in my undergraduate accounting program in business law. Again, I'm not an attorney, but there has to be an insolvency type situation or an inability to pay debt. I think that's a layman's understanding of what the threshold is for filing bankruptcy. You can't just say, oh, we don't like a rate order, and then go before the federal bankruptcy court and make a filing. Beyond that, though, if it were to come to a point of a bankruptcy, I've been involved in two utility bankruptcies, one involving Cajun Electric Cooperative on behalf of the Louisiana Public Service Commission, and one involving Big Rivers Electric Corporation in Kentucky on behalf of large customers of that utility. I've also been involved in a number of different utility proceedings in which the utility was under severe financial duress. But I can tell you with respect to the two utilities that actually did file for bankruptcy, they came out of that in two different situations. Cajun Electric Cooperative was liquidated, and its primary creditor was the U.S. government, the Rural Utility Service. And in exchange for that, the distribution cooperatives, which were the customers of Cajun Electric Cooperative, signed contracts for supply with Calpine and NRG, which provided a substantial reduction in their rates going forward. So they were protected. The lights never went out, and they got a better rate deal because, as is the case in bankruptcy, it's not a case where the judge has the power to set rates. In our experience, that has been clearly articulated by the federal courts. And again, I'm not an attorney, but in any event, the judge does not have the right to override the state rate-making process. So then when Big Rivers went into bankruptcy, and this was an issue in that bankruptcy as well, as to whether or not the State Public Service Commission had the right to set rates or whether the federal bankruptcy judge could override that. Again, I think there was a ruling by the courts that the Public Service Commission retained rate-making jurisdiction and did, in fact, exercise it. In neither of the utility bankruptcies, which I am familiar with, neither of those cases did the bankruptcy court set rates. And in both of those cases, the issues were all resolved through the bankruptcy court in conjunction with the Public Service Commission in each one of those states.
So there, and you described some of the, the negative consequences. There's, some concern about the bankruptcy court's rate-making authority, which is not really been upheld in my opinion, but also the credit metrics impact, which is negative of a bankruptcy. But are there potentially, from a public's perspective, some positives of the bankruptcy process? Is that in that some of this bad debt can be, or troublesome debt can be discharged or dealt with?
Yes. I don't think I would even begin to recommend in this case, that a bankruptcy or conclude that a bankruptcy filing was imminent. To the contrary, again, if it were under the ORS plan, then I am certain that Dominion or South Carolina Electric and Gas would have put in testimony to that effect. Neither party did. Now, if in some circumstance SCE&G or SCANA finds that it can and that it could be beneficial to enter into bankruptcy, I don't think, in my experience, that the lights will go out, because they never have. And I don't think you would lose your rate-making authority, because that never has happened, at least to my knowledge.
And I believe that
and the debt issues get resolved. That either the debt holders take a loss, basically, or their debt gets converted into equity, just like any other normal bankruptcy, but it gets resolved.
so there are a variety of ways in which the debt issue can be resolved in this situation.
Yes, that's correct.
One is through a merger, right?
Yes.
And one is through a bankruptcy.
If that's a path that the utility either A, can take, or B, if it can take it, decides to take it. I mean, it's not an obligation.
Have you seen any credible evidence in this case that that's even a likelihood?
I have not. There are several witnesses for Dominion and South Carolina Electric and Gas that addressed the credit metrics of the company. And despite all of the testimony describing the negative effects of the ORS plan, none of that testimony addressed a potential bankruptcy.
So as the commission is weighing these weighty decisions in this case, should they give much credit to any fear that such a bankruptcy scenario is likely, and that for that reason dump more cost onto the ratepayer side than the shareholder side?
Well, that's really the dilemma. Basically, Dominion and South Carolina Electric and Gas are arguing for more money because that will improve their credit metrics as opposed to the ORS plan. I accept that. More money means higher credit metrics. The question is, what is the right balance? And we think that the ORS plan is a balanced plan. For example, we provide a rate of return on equity that the company doesn't have right now with respect to the NND costs. And so even though we have a 9.1% rate of return on that equity, the equity itself is greater than what is on the company's books. So essentially, it's a balanced plan. We've given in certain areas with respect to the ORS plan, and it's not a punitive plan. It provides South Carolina Electric and Gas full recovery of all of the allowed NND costs, less the regulatory liabilities, provides them a traditional rate of return, including an equity rate of return on equity that they don't even have, and locks it in for the next 20 years. It's a guaranteed recovery for the next 20 years. That's why I say, despite all of the, at least, my impressions of reading some of the credit-related testimony of doom and gloom, I think that this is a fair and balanced plan that gives the company more recovery than their actual costs.
So the ORS optimal plan, as balanced as you think it is, allows this utility to earn a profit on a power plant that is not serving the public, probably never will, is no longer being constructed. Is that right?
That's a true statement.
And in arriving at this balance that I can see you've worked really hard to try to achieve here, would it be fair, or would it be good advice to this commission to not overly focus on credit metrics?
I think so, because, under all of the plans, including the Dominion Customer Benefit Plan, there are going to be additional impairment write-offs. That means that the South Carolina Electric and Gas common equity will be less. And it's not just under the ORS plan, it's true under the Dominion Customer Benefit Plan. Now, once that happens, and there's no cash involved with a write-off of, an impairment loss write-off, there is no cash involved. In fact, there's cash that will come in as a result of tax abandonment loss, which is part of the termination of the project. But in any event, that write-off that goes against common equity is not a cash write-off. It hits the income statement, it's one time, and then after that, the utility, and this is borne out by my experience, the utility will rebuild that common equity over time, and its credit metrics will improve.
And as I understand it, in your testimony, you didn't really delve into the issue of prudency.
I did not.
Right. But from your macroeconomic view of this case, should the commission be considering between the utility and the ratepayers, which side had control over this project and which side did not?
That's generally a factor in prudence. In my experience, customers don't have a direct management role in overseeing construction projects or the costs that are incurred. And so the commission, in representing customers, and to be fair, in a balanced manner, the utility as well, has to consider both the utility and the customers.
And would you agree with me that a very important tenet of cost of service regulation is that there are consequences for utility management decisions, and that the opportunity to earn a fair return is not a guarantee or
Yeah, I think generally I would agree with you on that. However, I would point out that the ORS optimal plan that provides recovery of the N&D cost is as close to a guarantee as you're going to get.
That's all that I have. Thank you. Mr. Chairman.
Thank you. We are at 4:20. Mr. Elliott, you've never done anything in 10 minutes since I've known you. Is that going to happen today, or is because I'm going to finish at 4:30? All right. Go for it then.
Mr. Collin, I'm Scott Elliott. I represent the South Carolina Energy Users Committee, the large industrial customers.
Okay.
Nice to meet you. Nice to see you again, I guess. Let me draw, Mr. Erskine, I'd like to give the witness the benefit of his PowerPoint. Can you help me? There you go. And I'd like you, Mr. Collin, if you would, could you put on the screen your table at the top of page 6 of 9 of your summary? And I can't read that from here. Is that it?
Well, I will check and we'll see once here.
It is.
There we go.
All right. And so I can't read that, but let me make sure I understand how to read it, if I may, please. If I look over here on the far right column, just the bottom line under Dominion Merger, do I understand this column to provide that under the Dominion merger plan that they put forward, Dominion proposes to put about $2.7 billion into rate base?
Yes.
All right. And do I understand, moving leftward, that under the E&G no merger plan, that E&G recommends a slightly smaller rate base of $2.67 billion. Do I understand that correctly?
That's right. And I should point out this is the ORS calculation of rate base under the two plans.
All right. Thank you. Helpful. And then last, going over to the ORS recommend, I'm just skipping over the securitization. Do I understand that the ORS proposes to put $712 million into rate base?
Yes, that's correct.
All right, good. Now, if you would please go back to the graph on page 4 of your testimony. It's the colorful graph that shows the rate impact. There you go. Now, as I understand this graph, the gold color would be the revenues generated by Dominion's recovery of the, we call it the N&D costs, the abandonment costs under their proposal. Is that correct?
That's right. You see the $1.3 billion upfront rate credit, and then you see the payback along with the other costs over the next 20-year period. Now, as I pointed out in my summary, even though that rate credit won't occur in 2018, we wanted to show that as a separate data point. So it would actually be netted in 2019.
That's a nice point, and I appreciate it. But my question is, under that gold line, Dominion would be recovering their NND costs, but with a return, would they not?
That's right.
And numbers aren't my thing, but they propose a return of maybe 10.75%.
They propose a return that consists of a capital structure that is fixed, consisting of both equity and debt, based upon the capital structure before South Carolina Electric and Gas started taking impairment losses in 2017. It was roughly 43% common equity and 57%, I think that's what it is, debt. Then and also a 5.58% cost, a 5.85% cost of long-term debt, and a 10.25% return on common equity. Now, keep in mind that this capital structure is not really their capital structure. It has more equity in it than is actually on their books because they've had impairment losses already.
Good. And the green line is the SCE&G no merger rate impact. Is that correct?
Right, and you see that extends over a 50-year period.
And the SCE&G would like to earn a profit on those costs too, wouldn't they?
Sure, yeah.
And there's a profit in that in the revenues generated by that green line.
Right, yeah, it's the same capital structure and the same cost of equity and the same cost of debt.
And last, by the same token, if you look at the blue line, that's the ORS proposal that would generate revenue of slightly under $100 million, but with a return of 9.1%, correct?
That's right. We use the same capital structure proposed by the applicants, and that would remain in place for the whole 20-year period or 50-year period in the case of the no merger alternative or plan. And but we used a lower cost of debt because South Carolina Electric and Gas issued hundreds of millions of dollars of new debt in August, roughly upper 3s to low 4%. And that, when you take that into account, it reduces the cost of debt to 5.56%. And we used a 9.1% return on equity. So the ORS plan includes a return on equity plus the income taxes on that return on equity, even though a good portion of that equity doesn't really even exist.
Thank you. Now, does Dominion propose in its merger plan to take the cost monthly to the ratepayers and have that cost put on its monthly bills?
Well, Dominion proposes to have the costs that it proposes on SCE&G customer bills.
Very fine. But does Dominion propose to set that the amount out separately that each ratepayer is paying to recover these abandonment costs?
I don't know. Probably Michael Seaman-Wynn would know that.
And of course, if Dominion were permitted to recover these abandonment costs with a profit, it would probably be helpful and instructive for its ratepayers to know just how much each month they're paying for the crumbling concrete and the rusting steel out in Jenkinsville, wouldn't it, sir?
I don't know. That would be a policy decision, I think, of the commission.
Well, no, sir. I think I asked if the question was, do you think it would be helpful to the ratepayer to know that number?
I don't know. It's a matter of judgment, and it's part of the rate process. It is a piece of valid information, but whether it would be helpful to customers, I don't really know.
Well, and you understand that the situation that you're in and that you're testifying about has been the subject of great public interest over the last 15 or so months, don't you, sir?
I do understand that, yes.
And you could understand as a result how the ratepayers might be upset about the prospects of this commission awarding abandonment costs with a profit that they have to pay for 20 to 50 years. You can understand that, can't you?
I understand the customers are concerned about how much they pay for utility service.
And as I understand the ORS optimal plan, you don't propose to ask this commission to put these rates, your proposed rates, on the monthly bill so that the customers will know what they're paying for the crumbling concrete and the rusting steel out in Jenkinsville.
I don't know. I'm not proposing that, but I don't know if another witness has proposed that.
Good. That's what I thought your answer was. Now let me ask you one last question. Turn now, if you would, to your chart on page 2. And I draw your attention specifically to the third line down, increase to recover NND costs less regulatory liabilities, CCR rider. Do you see that line? You do?
Yes, I do.
Yes, sir. And as I understand it, the ORS proposal is to charge ratepayers an amount equal to generate $85.9 million annually on these the steel and concrete out there in Jenkinsville?
Yes, less the related regulatory liabilities. I think I mentioned in my summary that normally the cost curve on a particular asset like NND costs would decline over time as the asset is depreciated. Well, what we did was we drew a line basically through the middle and on a net present value basis equivalent, then said we would calculate what I would call a levelized annual revenue recovery, and that's just like a home mortgage. So even though as you pay off your home mortgage, for example, your interest goes down and your principal payment goes up, but it's annuitized, it's levelized. Somebody drew a line through the middle of it and equivalenced it on a net present value basis, and that's what we did.
Thank you. And my question is, though, if this commission were, for whatever reason, to determine that neither Dominion nor SCE&G should be able to recover the NND costs at all, would the commission simply, and if the commission were to approve the ORS plan in all other respects, would it be a simple matter of eliminating the $85.9 million figure off this chart to come to the revenue benefit to the customer?
Well, I think that's right. There may be some tax implications of that, but generally I think that's right. I think conceptually we could view it that way.
Very fine, thanks. I appreciate it. Thank you for letting me get this in this afternoon, Mr. Chairman.
Thank you. Well, every day something amazes me. That was it. Yes, Mr. Burgess.
Mr. Chairman, just as a housekeeping matter for hearing Exhibit 46, which was a late filed exhibit requested by Commissioner Irvin. We have that document here, so I'll present that to the court reporter. And just for the sake of clarity, the company actually made 2 disclosures with respect to that agreement. One was made as an 8K in January of 2011, and then the agreement itself was followed up as an exhibit to the 10Q that was filed in May of 2011 as well.
Yes, sir, Mr. Ziegler.
And, Your Honor, as we did before, I would ask that the witness be instructed not to speak with counsel for either ORS or any of the other parties that are aligned with ORS pending the conclusion of his cross-examination.
Granted. Okay, we understand that, right, Mr. Collin?
Yes, I do.
Okay. Okay. We have reached 4:30, and we are adjourned.